Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. So I saw an article on the CBC which left me with a lot of questions, and I see a lot of other people discussing it, and they have questions too. The article is Man Who Killed Attacker in Banff Used Excessive Force, Sentenced to 2-year house arrest. And the first question I had when just reading the headline is, wait a minute, this guy got house arrest for a killing? That's unusual. Now, that would mean, of course, that this is a manslaughter conviction, and manslaughter actually has no mandatory minimum sentence. In theory, the court can give an absolute discharge for manslaughter, and an absolute discharge means that essentially they go, you did it, but we're not going to punish you. We're not even going to give you a criminal record. Now, clearly, 2 years of house arrest is more than an absolute discharge, but it's still less than you usually see in manslaughter cases. Usually a CSO is not on the table, so house arrest wouldn't be on the table, and usually the sentences are years of prison. Then I started reading the facts, and the facts on this one really said to me that this should have been an acquittal on self-defense. I was like, what's going on here? So what basically happens in the simplest sort of terms here is that Mr. Sproul, the accused, this is the King and Sproul, went out to go drinking and he ran into a guy riding Brogdon. Now, for some reason, this Brogdon guy took a dislike to him. Brogdon went up to the bouncers and was like, hey, do something about this guy. And now Sproul didn't know any of this. He didn't realize that Brogdon didn't like him. He wasn't aware of any of this. And so they go and they're doing their thing, and eventually they leave, and Sproul decides he's going to ask Brogdon for a cigarette. Now, he doesn't realize that Brogdon really dislikes him, and Brogdon starts a fight by shoving him, and then when Sproul is like, what the heck? Brogdon sucker punches him and proceeds to start beating him. Now, in the course of this, Sproul pulls out his work knife. He's got a work knife in his work pants and slashes and stabs and so forth. During much of this, he couldn't see because he was being jerseyed. It's the sort of Canadian hockey move where he's pulled his shirt over Sproul's head and Brogdon is punching him. Now, Brogdon gets stabbed repeatedly and slashed, and ultimately a bouncer pulls Brogdon off of Sproul. He's been stabbed a lot, but he's still fighting. And Sproul then runs away. Now, Brogdon doesn't make it. He dies. This is a common thing in knife fights. And Sproul is later arrested and charged with murder, which he's acquitted on the murder. But let's go to the original decision because it's going to explain things in a lot more detail. Now, I'm not actually going to go through the sentencing part of the sentencing decision. I'm going to talk about the facts, and I'm going to talk about this being a bit of an odd case. So we have His Majesty the King and John Stuart Sproul. And this is the sentencing decision of the Honorable Justice J.C. Price. Now, I am going to say I've seen a lot of people online discussing this and criticizing Justice Price. I don't have any criticisms for Justice Price. I think Price did a reasonable and a good job here. And I also think, reading between the lines, that if this was a judge-alone trial, that the justice would have acquitted. That's my read. That's my guess. I can't say for certain because, of course, I don't have the ability to read minds. But the jury seems to have convicted in a situation where I think the justice wouldn't have, and that's a little bit unusual. So on March 5th, 2025, a jury found John Stuart Sproul not guilty of second-degree murder, but guilty of the lesser and included offense of manslaughter in the death of Ryan Brogdon. Now, the Crown was going for murder on this one, and as you're going to see, murder seems to be a real reach because, yeah. So Ryan died just after midnight on September 3rd in Banff, Alberta. This was the senseless and tragic death culminating from a verbal altercation that started over a cigarette. Now, it doesn't really start over a cigarette when we get to the sort of more fulsome reading of things, because it appears that Brogdon just really hated this guy. Like, that seems to be what we get out of this. And that it wasn't like they were fighting over the cigarette. It's just that he just really doesn't like this guy and went after him for some reason. So the verbal altercation escalated into punches being thrown and then a pocket knife being used. Ryden died from his injuries after receiving multiple knife wounds from John, 3 of which were fatal. It is my responsibility to consider the circumstance of the offense and the sentencing principles in crafting a fit and appropriate sentence for John for the crime of unlawfully causing the death of Ryden. Now, here's the thing. This is the jury trial. So the jury decides, what to convict on and so forth. But the jury doesn't then explain what facts they found. They don't provide any details. And so after the jury says we convict, it goes back to the justice, and the justice has to say, well, I have to determine what facts I consider would have been found by the jury. So that has to be consistent with the verdict, but beyond that, the justice is going to use their own sort of rationale and examine the facts and decide what was proven and what was not. So it's a bit of a weird kind of hybrid thing where the jury is like, not guilty of murder, guilty of manslaughter, and the justice then has to decide what that means in terms of what specifically happened, right? So we're going to skip over a little bit, and we're going to look at the parties' positions. So the Crown submits that a fit and appropriate sentence for John is 5 to 6 years in jail. Now, I said I have no criticisms for the justice here. I do have some criticisms for the Crown, because, seriously? This case, I've got some problems with it. So the Crown acknowledges that the duration of John's unlawful act resulting in the death of Ryden was short, and that John's decision to use his pocket knife was in response to the verbal altercation and the fight that ensued. There was provocation from Ryden, as he had sucker punched John in the face, then engaged with John and dragged John down the street. I would say that's not so much provocation, that is a direct physical attack, right? At some point, John was pressed against a picnic table with Ryden on top of him. The Crown concedes that these circumstances mitigate what would otherwise be an unlawful act causing death at the highest end of the moral culpability scale. However, the Crown submits that John's moral blameworthiness remains at the highest end considering the degree of violence or brutality of John's actions. Ryden's death was not a matter of chance, as he suffered 3 fatal wounds in addition to the wounds to the groin and neck that landed near major veins and arteries. Now, to my mind, there's a bit of a disconnect here. And the disconnect really comes up when you're talking about 19 stab wounds. And one of the things is that knives are very poor for stopping power, which in some ways makes knives a very poor self-defense choice. And what I mean by this is that knives, they are lethal long before they actually stop a fight. So, for example, you can have stab wounds in both lungs and your liver and your kidneys and all of these places and still be up and moving and a potentially lethal threat to other people for a fairly long time. This is why the old adage is that when 2 people have a knife fight, the winner dies in the, in the hospital or in the ambulance, and the loser dies on scene, is that they both have killed each other, but they were still fighting in the interim time. This tends to also get reflected in court proceedings because you get things like the Crown talking about the degree of violence or brutality because there wasn't just one stab wound. But as we'll see, Ryden was still fighting right up until eventually a bouncer intervenes. So notwithstanding that he took a large number of slash and stab wounds, he was still in the fight. He was very much still in the fight, and in fact, keen to continue the fight. So, with respect to aggravating factors, now aggravating factors are things that make it worse, right? That increase the sentence. The Crown submits that the use of the pocket knife was aggravating, as was the extent of Ryden's bodily injuries. In addition, the Crown submits that I should find it aggravating that John fled the scene without offering assistance to Ryden, we're going to see that that is something that the justice does not agree with. In fact, several of the Crown's positions we will see that the justice disagrees with. So, defense counsel submits that given the unique facts of this case, an appropriately crafted conditional sentence order, otherwise referred to as a CSO, would be proportionate to the gravity of the offense and John's moral culpability. In the alternative, defense submits that John should not be sentenced to more than 18 months in jail and should be given credit for the 98 days he spent in custody and the 1,033 days spent under strict conditions while released on bail. Now, I'm just going to say, I think defense counsel did a really good job on the sentencing here. This is they got what they were asking for. Defense counsel further submits that the Crown's sentencing position in supporting cases demonstrate a clear disregard of the important context in this case. Defense asks that I consider the point of view that John was the victim of a violent and unprovoked assault by Ryden before he used the knife in self-defense, but that John used more force than was necessary to repel Ryden's relentless attack. Now, why would he say that John used more force than was necessary when, he never actually was successful in repelling Ryden's relentless attack? Ryden was attacking him right up until, a bouncer pulls him off. Well, defense counsel is bound by the jury's verdict, right? And when the jury is convicting on the manslaughter, clearly they're finding that more force than was necessary was used. So, defense counsel submits that within this context, the appropriate categorization within the manslaughter sentencing framework is conduct objectively likely to cause serious bodily harm. The defense's position falls into the mid-range of the moral blameworthiness scale. All right, let's, and they also note, defense counsel acknowledged that the use of the pocket knife and the extent of Ryden's injuries are aggravating factors. However, defense argues that those aggravating factors have to be considered in the context of this case, that John was not intentionally carrying the knife for a purpose dangerous to the public peace, and that he used the knife reactively to defend himself, but used too much force and not proactively. Okay, now we're going to skip ahead a whole bunch here in terms of sentencing principles, and we're also going to see there's victim impact statements which talk about Ryden, and they say he was a great guy. That is usually the case when there's a fatality because everybody is awesome in death. It just is the case. But they had 75 total victim impact statements, and they said he was cherished by many as a son, a brother, a grandson, nephew, cousin, soon-to-be uncle, and a good friend to many. Ryden was described as a loving, happy person, a generous person who loved animals, especially his dogs. He was described as a people person, passionate about music and photography. He was an avid outdoorsman who enjoyed nature, backcountry hiking, and fly fishing. His life was characterized by adventure, love, and creativity. Now, the thing is that at the end of the day, he's also the guy who picked a fight and attacked a guy and continued attacking him, even as this person was apparently trying to get away. So that is, that's something else. There's the other side. John's personal circumstances. So he wrote a letter. He had a book of character references, 18 letters of support from family, friends, and community members, including neighbors and work-related colleagues. He says he takes full responsibility for his actions and the consequences that followed. And he says he's committed to a different path, one grounded in peace, personal accountability, and an unwavering respect for the sanctity of life. All right. We'll sort of move on here and we'll look at the description of the sort of findings of fact. So at the hearing to address the findings of fact, it was disputed that John possessed the pocket knife for a purpose dangerous to the public peace. So one of the things that would be dangerous to the public peace is just for self-defense, right? If he was carrying this knife around, to defend himself, then Canadian law would say that that was a crime and would be an aggravating factor, right? So the Crown argued that the only logical conclusion was that John felt confident enough to square up with the considerably larger Ryden because John was aware that the knife was in his pocket and he was prepared to use it on Ryden. The Crown relied on the evidence of Howard, that's Ryden's friend, who testified before the jury that he heard John say words to the effect of, "Do you want to get fucking shanked?" However, key aspects of Howard's testimony were found to be inconsistent and at times contradicted by the video evidence. Whoops. That's one of those little problems when your testimony turns out to not match the video. Yeah. Howard was not found to be a reliable witness. Now, I don't know if Howard is, like, if he's misremembering this. People, like, memory is a constructive process and a reconstructive process. So your emotions about an event can change how you remember it and warp it in ways that lead it to be inaccurate. But he may also have just been not honest. I don't know which is the case. So his testimony of what he said he heard John say was not believed. Further, I did not accept the Crown's theory that John had taken the knife out of his pocket before he was on the street in front of the McDonald's. That fact was not proven. Ultimately, on the issue of the pocket knife, I found the Crown failed to prove beyond a reasonable doubt that John possessed the knife for a purpose dangerous to the public peace. And what we see here, with the little sticker there, but what we see is that John seems to have had a work knife and, just was keeping it in his work pants. So not a purpose dangerous to the public peace. He's just got, it's a work tool, right? The other disputed fact argued at the findings of fact hearing was whether the fight between Ryden and John was consensual. Now, you can have a consensual fight, right? You can agree to get into a fist fight within limits. Those limits are you can't cause serious bodily harm. But the Crown argued that the incident between Ryden and John started as a consensual fight that turned into a violent and intentional assault by John on Ryden that caused Ryden's death. In this regard, I found the facts proven were that Ryden pushed and then sucker punched John. I further found that John tried to disengage from Ryden, but that Ryden had the upper hand over John. On this basis, I found the Crown had not proven on any standard that the fight between Ryden and John was consensual. So, first, it's not consensual because Ryden sucker punched him. It wasn't like they agreed that they were going to have a fight. He just gets punched out of nowhere. The other thing is that even if you have a consensual fight, if you agree to a fight, the instant somebody says, "Whoa, I'm done. I don't want to fight anymore," that fight stops being consensual, right? If you're having a consensual fight and somebody says, "Stop," you have to stop. In the same way, if you're in a boxing match or something and the guy is like, "Stop, I gotta quit," you can't keep punching him, right? So the Crown's theory here, the Crown's argument, the judge is like, no, that is not the case. And so for the people who are out there criticizing the judge and saying, hey, this guy is, the judge is against, John here, the judge, doesn't get it. The judge actually does. It's the Crown that seems to not get it. And yeah. The additional findings of fact that were proven to permit a proper sentence to be imposed on John included the following. So this is what the justice finds as a fact happened. So on September 2nd, 2022, John was in Banff for a family vacation. He drove from Fernie, BC, where he was working at the time, to meet his family, mother, father, brother, auntie, uncle, and his grandmother, and another uncle who were in Canada visiting from Mexico. The family ate dinner at the restaurant in the same hotel they were staying at in Banff. After dinner, John and his younger brother Josh left to explore the nightlife in Banff. They're like, all right, let's go have some fun. We're in Banff. We're going to have a party. The brothers consumed alcohol and attended multiple venues throughout the evening. The brothers were in good spirits and engaged in friendly conversations with patrons and staff at various venues. So they seemed to be friendly folks, right? The last bar the brothers attended prior to the incident was High Rollers. While in the venue, John was in good spirits, dancing and having fun. Ryden and Howard were behind John and Josh in line to get into High Rollers. They noticed the brothers in line ahead of them. Ryden and Howard spoke with the bouncer about the brothers when they entered the bar. Ryden and Howard kept eyes on the brother in High Rollers bar. So, for some reason, these two take a dislike to the two brothers. John was unaware of Ryden's presence at High Rollers and had no interaction with him nor Howard. He was unaware that Ryden and Howard were holding animosity towards him and Josh. And it's unclear from this decision why they decided that they didn't like, these two people. But it seems that they just, sort of got a stink in their head about these two. And it doesn't end well. So John believed that Josh was too intoxicated to remain at High Rollers, and the two of them departed for their hotel. He's like, hey man, you've had enough. Let's get you back to the hotel. Ryden and Howard exited High Rollers just ahead of John and Josh. While John and Josh were walking back to their hotel, John approached Ryden, who was smoking a cigarette, and asked for one. I don't smoke, but this is really common. Like, I have seen smokers do this a ton. So, yeah, just a fairly ordinary interaction, right? In response to the request for a cigarette, Ryden pushed John unexpectedly and told John to fuck off. Now, I mean, if he just said fuck off, it probably would have been the end of things, right? They probably would have been like, okay, man, and then just kept on going. But he also pushed him. And so John replied by stating words, and at this point, Ryden is assaulting John, right? He's starting the fight. At this point, the fight is on, at least to a certain extent. Had Ryden lived, he could have been prosecuted for that push. So John replied by stating words to the effect of, what the fuck? Or what the fuck was that for? Ryden once again told John to fuck off and pushed him in the chest, forcing John backwards. So he's coming up and shoving him again. This is clear spoiling for a fight behavior, right? And at this point, when you see this kind of thing rolling up, it's time to go. Because, yeah. John responded by saying words to the effect of, hey man, what the fuck is your problem? You'll notice one side is using physical violence and the other side is using their words at this point. Josh stepped in between Ryden and John and was immediately pushed by Ryden and then held back by Howard. So we can see that Josh tries to get in and tries to intervene, but Howard is like, nope, and that's Ryden's friend. Howard seems to own some responsibility for what goes down here, not in the legal sense, but in a moral sense. And yeah, that's probably a difficult thing to live with. John stepped around Josh and was in the process of saying words to the effect of, what the fuck, when Ryden sucker punched John in the face. After punching John in the face, the two began a punching match. But Ryden, who was taller and older than John, had the upper hand and grabbed John by the shirt and spun him around onto the street from the sidewalk and continued to punch John. At the point they entered the street, Josh intervened in an attempt to protect his brother by punching Ryden. Following this intervention by Josh, Howard pulled Josh headfirst back onto the sidewalk and punched Josh in the head twice before a bouncer intervened. Meanwhile, Ryden spun John again while on the street where picnic tables were set up as an outdoor dining area. While on the street, Ryden continued to strike John. At certain points, John's shirt was covering his face and he was unable to see. So he's really not doing well in this fight, right? He's getting his butt kicked is quite frankly what's going on. At certain points, there's pictures that show John afterwards. And he had a bleeding nose. He's got, other substantial injuries. He was taken to the hospital as a result of his injuries. One thing to also consider is that there's a wealth of case law about one-punch manslaughter cases where people die from a single punch. Getting punched repeatedly in the head is potentially life-threatening. It's not like, oh, whatever. It can kill you. And it can cause brain damage. It can cause life-altering, ruining sorts of injuries. So when you've got somebody who's got you unable to see and is punching you repeatedly in the head, this is concerning. Now it gets even more concerning because Ryden states his intentions. They say, at certain points, John was in a seated position pressed against a picnic table while Ryden was standing above him. During the fight, Ryden said words to the effect of, I'm going to kill you, and you are fucking dead. So this guy who attacks John for apparently no reason, and is beating the hell out of him and is saying, "I'm going to kill you," to me seems to be a serious threat to life, right? This is the kind of thing people are afraid of, right? That some random crazy guy can just go after them and maybe kill them. And but for the knife in this case, it could be that this case could have been, the King in Brogden for Ryden being charged for killing John. It's an easy, counterfactual to think of here. So at an unknown point, when John was on the street in front of McDonald's and engaged with Ryden, he removed his work pocket knife from his jeans, opened the knife, and began blindly slashing and stabbing at Ryden. He can't see. He's got the shirt pulled over his head. He's just getting the crap beat out of him, and he can't even see to fight back or defend himself. So he gets out the knife, and he's now trying to basically get this guy off him with the knife. So he began blindly slashing and stabbing at Ryden. John did not know where he was connecting in his wild swings. John used the knife in an effort to repel Ryden's attack. You can see here, reading between the lines, my strong suspicion is that if this had been a justice alone trial where the justice gets to make the decision on self-defense, I think the justice would have acquitted. That's my take on this. And I don't find it to be that the justice would have been unreasonable to do so. I suspect that the jury did a compromise verdict. The jury was given second-degree murder, and they probably said, "Oh, well, we'll just compromise on manslaughter," when they should have said, "No, this is clear self-defense." I mean, this to me seems like clear self-defense. So notwithstanding he was stabbed and slashed 19 times, Ryden did not stop his attack on John until a bouncer physically pulled him off of John. So this is not a case where the fight's over and he keeps stabbing, or that Ryden goes down and John keeps stabbing. It's in fact Ryden was still fighting and still trying to hurt him, even though he'd taken all of those injuries. So when the bouncer physically pulled Ryden off of John, John stopped swinging the knife and immediately ran away in fear. The entire interaction between them from start to finish was approximately 60 seconds. So when people say, "Oh, just call the police," this entire lethal altercation was 60 seconds, and there is no way the police show up in under a minute. Just there isn't. They're lucky that the bouncer was there. The interaction between Ryden and John on the street in front of McDonald's when the knife was used was about 22 seconds. So whenever you think about hey, I called 911, keep in mind that the rest of your life might be 22 seconds long. Something to consider and something to think about. John dropped the pocket knife not far from where the incident occurred and fled in fear of Ryden. John believed he was being chased through the town of Banff by Ryden and unknown others. So he's fleeing because he thinks this guy might still be after him. At one point, while fleeing through Banff, John saw what he believed to be his hotel and attempted to enter a unit, wrongly believing his family was behind the door. After failing to gain access to the unit, John heard unknown people walking up the stairs of the complex and believed it was Ryden and unknown others still chasing him. As a result of this belief, John climbed onto the roof of the building. Shortly after accessing the roof, John saw a police vehicle on the street and jumped off the roof to seek help from the police officer. This is really what you'd expect a murderer to do, right? Murderers run towards the police and are like, "Help, help," right? Not usually. But this guy is running towards the police. This is what, sort of every self-defense seminar and primer and whatever says, is go to the police. And shortly after landing on the ground, police arrived on scene and took custody of John for assault. So John did not know he had killed Ryden until after he was in custody and had arrived at the hospital in Banff to seek treatment for the injuries he sustained. So the police arrested him, and then they were like, "All right, you're under arrest, but clearly you need medical attention." So the police took him to the hospital. Very common when the police arrest somebody with injuries. Upon John's arrival at the hospital, Howard was already there. And Howard threw a water bottle toward John and the arresting officer and yelled, "You killed my friend." The injuries sustained by John included 2 lacerations under the chin, gaping but superficial, did not penetrate below the subcutaneous layer. B, 4 superficial lacerations to the back of his hands and fingers. C, left periorbital soft tissue contusion swelling, so a black eye, left eye swollen shut. And D, 1 suspected right mandible fracture, broken jaw. And E, injured right hip and pelvis, causing a limp. So he got beat up fairly good. But John, of course, inflicted 12 stab wounds and 7 incise wounds, i.e. slashing wounds, on Ryden. 3 of the stab wounds were fatal injuries. 1, a stab wound to the right chest that punctured the upper lobe of the right lung, resulting in significant hemorrhage into the right chest cavity. So, he's bleeding into his lungs, and the blood loss, was enough to be fatal. 2, a gaping stab wound to the left chest that punctured the upper left lobe of the left lung, resulting in hemorrhage into the left chest cavity. This is, the combination of those two is going to be really bad because both lungs filling with blood is going to be lethal fairly quickly. But not quickly enough when you're talking about altercations that last 60 seconds, right? And 3, a gaping stab wound extending from the central pubic region to the upper right thigh that severed the external iliac artery and vein. There are some really important arteries in that region. So John was defending himself throughout the attack on him by Ryden. However, John's response was excessive. Stabbing and slashing Ryden a total of 19 times was more force than necessary to repel the attack by Ryden. Now, the justice has to make this finding because the jury convicted. Like, the justice is limited there. But I'm like, was it really more force than necessary to repel the attack by Ryden? Because it didn't actually succeed in repelling the attack by Ryden. But for the intervention of the bouncer, Ryden was still beaten on him. Like, this was actually insufficient force to repel the attack by Ryden when you actually, break this down and look at it. So the excessive lethal effect went beyond the protection afforded to him by Section 34, Sub 1 of the Criminal Code. Again, that's the finding of the jury, so the justice is bound by it. John caused Ryden's death by means of an objectively dangerous, unlawful act, and a reasonable person would have foreseen the risk of bodily harm, which is neither trivial nor transitory, resulting from the unlawful act. Clearly, the gravity of the offense in this case is high, and the loss of life is the greatest harm that can fall on a victim. Ryden died because of John's actions. Now, I look at this and I go, wait a minute. I've got a bit, I don't agree that this was more force than necessary to stop the attack, because in fact it didn't stop the attack, right? And I feel like part of the problem here is that juries and this Crown prosecutor and so forth don't really understand self-defense and knives and so forth, because you look at this and you say, well, it's 19 stab wounds. Clearly that's excessive. And at the end of the day, if he hadn't had the knife, this could very well have been, a fatality. Similarly, if the bouncer hadn't been there to intervene, and there's no indication that John Sproul knew that the bouncer was going to intervene, because maybe if he knew the bouncer was on his way, he might have not stabbed anybody, but he's got the shirt over his head, right? He can't tell what's going on. He doesn't know. So, but for the bouncer, it might have been that Sproul also dies of his injuries or suffers brain damage or something along those lines. To my mind, this really indicates a problem with our self-defense laws, because ultimately the deceased in this case, like the dead guy, is far more the problem here. What did John do to start this fight? He asks for a cigarette. And if bumming a cigarette was enough to, get a beat down, then the streets would be awash with blood, right? Because people bum cigarettes all the time. The number of people I've had approach me and go, "Hey man, can I borrow can I have a cigarette?" And I don't smoke. I don't have cigarettes. I imagine it happens much more often if you're sitting there actually smoking a cigarette, that you'll have people come up and go, "Hey man, can I have a cigarette?" Like, you can just say no. If, if the dead guy here had just said, "You know what? No, I'm not giving you a cigarette. Leave me alone." End of thing, right? Maybe John goes and buys a cigarette at the a pack of cigarettes at the convenience store. Maybe he doesn't, like, who knows, right? But it's very difficult to see from these circumstances that, that a fight would have happened if he just said no, as opposed to no and physically attacking the person for asking for a cigarette. And, when you see here, they say, "Oh, well, he, this was a fight over a cigarette." I don't think the cigarette was the issue, right? The issue appears to be that, that Ryden was really keen to fight this guy. He doesn't like this guy. He, in fact, hates this guy for some reason that we don't know, that's unclear. And yeah, it's just a weird case. And in fact, we see that Ryden was bigger and older and, was a more, and in fact, not only can we infer that he was just from size, that he was a bigger, stronger guy and thus more likely to win the fight. He was winning the fight. He was absolutely winning the fight. He was beating the heck out of John. So, yeah. The court also finds, they say it also cannot be forgotten that there were two others involved: Josh, John's brother, and Howard, Ryden's friend. Josh tried to intervene in the fight between Ryden and John, but Howard would not let him. In fact, if Howard had let him intervene, Ryden would probably be alive right now. So, as was found, Ryden verbally threatened to kill John. John was blindly slashing and stabbing at Ryden. John did not know where his pocket knife was connecting. There was no planning or deliberation involved. The fight stopped when the bouncer took Ryden off of John. There was no additional gratuitous violence. John fled in fear of Ryden and dropped the knife nearby. John did not know he had stabbed Ryden to death. The whole altercation from beginning to end was 60 seconds. Of the 60 seconds, 22 seconds were of John blindly slashing and stabbing at Ryden, not knowing where his blind slashes and stabs were connecting. John did not suffer life-threatening injuries, but he did suffer injuries from Ryden's attack. And the thing is the next punch could have been life-threatening or life-ending, right? Every punch you take can potentially kill you. It's not, it may not be the most likely, but the case law is, and the cemeteries are full of people who just took one punch. Just one punch is enough to do it, right? And so, you've got a guy, you're blind, you're unable to see. It's got to be terrifying as you're getting hit repeatedly in the head by a guy who is telling you that his plan is to kill you. What would you do, right? Would you not reach for a knife in your pocket if you had one? I'm just trying to think of what John ought to have done. Like, what does the jury think that he ought to have done differently? How do they think that he ought to have conducted himself? I can't see it, right? I can't see a reasonable response other than what he did. So the court also has some further commentary, aggravating factors. The Crown submitted in written argument that I should find it aggravating that John did not offer assistance to Ryden after the incident. However, it was a finding of fact that John fled in fear of Ryden, believing he was being chased through the town of Banff by Ryden and unknown others. Like, he thought Ryden is still trying to kill him. So he's not offering assistance because he thinks this guy is still fine and gonna kill him. John did not know that he'd stabbed Ryden to death. This is not a case where an offender knowingly leaves the victim alone to die without providing or calling for life-saving assistance. And in fact, when he left Ryden was with a bouncer. So he's got help there. I imagine the bouncer called for, medical assistance and so forth. It's not detailed here, but I imagine that's likely what happened. The Crown failed to establish beyond a reasonable doubt that John knowingly left Ryden to die. Accordingly, based on the facts that were found, I do not find it aggravating that John fled the scene of the altercation without offering Ryden assistance. And so you can see a lot of this here is that the Crown prosecutor appears in the sentencing to be arguing a case that the justice says never happened. The justice here is saying, whoa, whoa, whoa. The Crown is going, he started this fight, and it was a consensual fight that he decided to bring a knife to, and he was willing to get into this knife fight, or into this fight, because he had the knife, and he was planning to use it the whole time. And, and then he cruelly left him to die. And the justice is like, but we live in reality, and you're in some other planet here. So, what are you talking about? Like, Crown, come on. What are you talking about? So, yeah. The court goes through a whole bunch of case law, and we're going to skip over that because it's just a bunch of other cases where things happened. And yeah, we'll skip over that just for time reasons. But ultimately, the court, when looking at it, looks at Proulx, which is a Supreme Court decision about what the court must consider when contemplating a conditional sentence order. Now, a conditional sentence order is kind of one of the ways the justice system lies to itself, because the court says that a conditional sentence order is equivalent to jail. And literally nobody on the planet considers it equivalent to jail except the courts. It's one of these happy little lies that we all tell, it's what you'd call a legal fiction. But, they are available, and sometimes a conditional sentence order, makes sense. So, requirements. The offender must be convicted of an offense that is not punishable by a minimum term of imprisonment. I.e., if the law says you got to go to jail, then you got to go to jail. The court must impose a term of imprisonment of less than 2 years. The safety of the community would not be endangered by the offender serving the sentence in the community, and a conditional sentence would be consistent with the fundamental principles of purpose and principles of sentencing set out in the criminal code. So the court notes, in this case, the first criterion is met, as there is no mandatory minimum term of imprisonment for manslaughter where a firearm is not involved. Note that in the Cahill decision, there was a firearm, so he could not get a house arrest sentence. In the result, the court can impose a term of imprisonment of less than 2 years. Additionally, in this case, John has been on house arrest since December of 2022. He is not reoffended and has adhered to strict bail conditions. Furthermore, before the incident and since his release on bail, John has been gainfully employed and has been a contributing member to society. These facts establish that John is not a danger to the community. Given that the first 3 criteria are met in this case, that leaves the last criterion on which whether a conditional sentence would be consistent with the fundamental purpose and principles of sentencing. So, they note, sentence must be proportionate to the gravity of the offense and the degree of responsibility of the offender. Denunciation, which is basically, you did a bad thing and we condemn it. And deterrence. And deterrence is split up into 2 categories of deterrence. There is specific deterrence, which is you, the particular person in front of the court right now today, must be scared off from doing this again. And there's general deterrence, which is other people who are aware of this case must be made more afraid of committing this kind of offense because they've heard of this one. So our primary considerations for a manslaughter conviction. It must also reflect the objectives of rehabilitation, separation from society where necessary, reparation, and promotion of responsibility in offenders. The principle of parity requires that sentences be similar to those imposed on similar offenders committed in similar circumstances. So, They note a CSO can still provide significant denunciation and deterrence, but it won't always be enough. It won't always be appropriate. Okay, so they find that the Crown's case, so they look at the Crown's cases and they say, although the Crown's cases, which were for like, the 5-6 year range, demonstrate that incarceration is a common outcome in sentencing and manslaughter cases involving stabbings, their cases are distinguishable on the facts of this case. With few exceptions that I find are distinguishable on the facts, none of the Crown's cases involve a finding of provocation and near self-defense, nor do they involve the type or number of mitigating circumstances that exist in this case. The court is like, this guy really isn't such a bad dude. With respect to the defense's cases, many of the cases cited did not involve the use of weapons and therefore were not as helpful as parody cases. The decisions in Clemens and Alphonse are most analogous, as both involve elements of near self-defense and /or provocation. Now, I mean, I'm hesitant to even say provocation is appropriate, because it's not that he was provoked and made mad. It's that he was in fear of his life, right? You can see that he's in fear when the first thing that happens when they're broken up is he takes off running, afraid of the guy. While a sentence of a CSO for manslaughter is less common, it is clear that it is still available in appropriate circumstances. They say this is a challenging case, and I acknowledge that it may be difficult to understand how a person could stab and kill another person and not face imprisonment. And I don't find this to be difficult to understand. I find this, the part that I find difficult to understand is why he was convicted at all, not why he gets house arrest. However, I find that the surrounding circumstances of the offense and the personal circumstance of the offender are exceptional in this case that warrant the consideration of a conditional sentence. All right, so skipping along a little further here, they find that there is no need to separate John from society, as they find that John is not a danger to society. And ultimately, he is sentenced to 2 years less 1 day, so 1 day less than 2 years, to be served in the community, followed by 2 years of probation. I recognize that you have spent 98 days in pretrial custody and you have spent over 1,033 days on onerous house arrest bail conditions. However, the time already spent by you does not reduce the length of this conditional sentence order or probation order. I mean, I don't think he's going to be too upset by that. You will serve this sentence in the community subject to your complying with conditions. The punitive and restrictive conditions are: A, you must keep the peace and be of good behavior. What this condition means is that any criminal activity, like any crime, in fact, even like regulatory violations in theory, are a breach of the CSO. And what happens when somebody breaches the terms of a conditional sentence order is that they will be brought back in, and the court has a number of options. And those options include what's called collapse, which means that the court can say, okay, the rest of your CSO is just going to turn into jail time. You just do it as jail time. That's it. Straight jail. Off you go. Not a fun circumstance. So he's got to be on his very bestest behavior. Appear before the court when required to do so by the court. Now, both of those are mandatory conditions just on any CSO. They appear on every one of them. Full stop. So you must report in person to a supervisor or probation officer at the RCMP detachment in Lake County, BC or Kelowna, BC within 72 hours after the making of this conditional sentence order, and thereafter when required by the supervisor and in the manner directed by the supervisor. What is the purpose of the supervisor? Well, there's a whole bunch of things that, require the intervention or involvement of a supervisor, and the supervisor is basically empowered to help enforce this, right? So that the judge doesn't have to do every little thing. So if at any time prior to the expiration of this order you are arrested, detained, or have served a sentence for another offense, you must report to the supervisor within 2 business days of your release from custody. So if you get charged, you got to go in, you got to let them know. When first reporting to the supervisor, you must inform him or her of your residential address and phone number. You must not change your residence or phone number without written permission from your supervisor. You must maintain both a landline and a cellular phone line. Okay, let's talk about this. So why does the supervisor need to know where he lives? Well, because he's going to be on house arrest. And that's also why he's got to maintain a landline, because when you're on house arrest, they will actually check in and they'll make sure that you are at your house. And they'll do this randomly. Like they'll just do it on every so often just to be like, okay, we're going to make sure that you are doing what you're supposed to do. And there's two different ways they can check in. One is they physically go to your house and they knock on the door and you gotta say that you're there. Or they might phone you and check that you're there. And the reason why they phone you on your landline is because, obviously if you're picking up the landline, you're at home. At least that's the idea. The supervisor, at their discretion, may require you to report to or attend at the RCMP detachment in Lake County, BC or Kelowna, BC. Your supervisor may require you to report or attend by electronic means or by your personal attendance. So either you might have to phone in or you might have to go in person. For the duration of this order, you must obey a curfew by being inside of your residence or on the lot of your residence 24 hours a day, 7 days a week. So it's not really a curfew when it's full time, right? You must present yourself immediately at the door to your residence or answer the phone when any peace officer or supervisor attends at your residence or calls to check your compliance with the curfew condition of this order. By the way, they often show up at like 2 a.m. and you have to wake up. Like, rise and shine. Got to get to the door because otherwise they will breach you. You may be away from your residence during the curfew hours with the written permission of your supervisor because there's things you got to do, right? You can't just stay in your house because you got things you must attend to. So such permission is to be given only for compelling reasons. You must carry the written permission when you're outside your residence during the curfew hours. So if a cop sees you and goes, hey, what are you doing? You can show them, right? You may also be away from your residence during the curfew hours, 1, while in the course of your employment or when traveling directly to or returning directly from your place of employment. So he can still go to work, right? And he's got to tell his supervisor like where he works and when he works. 2, in the event of a medical emergency, and then only while at a healthcare facility or when traveling directly to or returning directly from the facility. If you got to go to the hospital, that's allowed. You don't have to call your supervisor and be like, can I go to the hospital? I am dying. And they're like, let me think about it. Call you back tomorrow. So if requested, you must provide your supervisor with written confirmation that you went to the facility, signed by a representative of the healthcare facility to which you went. So they can hold you to account. Court professional appointments, i.e. with your lawyer, court-appointed counsel or court-ordered counseling or treatment sessions, and supervisor reporting appointments. Attending church. Now, if you don't go to church, then you don't get to go, right? But this provides a reason to find religion if you are on a CSO. Or shopping for the necessities of life as authorized in writing by your supervisor. Usually they'll say something like you can go for 2 hours a week, just to go and grocery shop and, buy medications and stuff like that, right? Attending at a gym or similar location for physical activity. This would have been requested specifically, I think. This is not sort of a common or ordinary term, but he probably was like, can I go to the gym? And the court's like, yeah, reasonable, fair. So as many as 3 times per week for as many as 2 hours each time or more. The location, schedule, and time for the physical activity to be approved in writing by your supervisor. And in the immediate presence of your mother or your father, so he's allowed to go out and about so long as they're watching him, and any other exception to be approved in writing by your supervisor. So the supervisor's got a lot of flexibility. So if he's like, hey, my best friend's getting married, can I go to the wedding? And the supervisor might go, yes, you can go to the wedding. You are not allowed to go to the, the bachelor party, and you are not allowed to drink at the wedding, right? They might say something like that. So you are to remain in British Columbia, except you may attend court appearances in Alberta or as approved by a judge of the Court of King's Bench of Alberta. You're banned from attending the town of Banff, Alberta for the time. Do not contact or communicate directly or indirectly with the Brogdon family. You must not possess or consume alcohol, drugs, or any other intoxicating substance except in accordance with a medical prescription. You must not enter any liquor store, beer and wine store, bar, pub, lounge, nightclub, beer garden, or any other business from which minors are prohibited at any time by the terms of a liquor license. So you can go to restaurants, but you can't go to the bar. You must attend, participate in, and successfully complete any intake, assessment, counseling, or program as directed by the supervisor. Supervisor has a lot of power there to decide things. And they say, without limiting the general nature of this condition, the intakes, assessments, counseling, or programs may relate to anger management and mental health. Now, this isn't a must. Sometimes the court will say, must do those things. In this case, the court is like, think about this, supervisor, but I'm leaving it up to you, right? Supervisor gets to make the call. You must perform 240 hours of community service as approved by your supervisor during the first 24 months of your sentence. Why do they say during the first 24 months? Well, because they don't want to have it be for the full term. Because let's say it gets to the end of the first year and he's done 0 hours, right? He's done nothing. Well, they want to still have a year left to be like, okay, now you get to do the rest of the year in jail, right? Whereas if they said, you must perform 240 hours of community service during the entire term, then he's like, well, I haven't breached it until the last day, and at the last day, you can't really punish me for it. So, yeah, they make them do it ahead of time. Must not possess any knife except for the immediate preparation or eating of food, or for purposes directly and immediately related to your employment. I don't like the way this term is phrased because, I'm in possession of knives right now. They're in my kitchen block, right? And, legally, that's possession of the knife. It's not on my person. Like, if you jumped through the window right now and attacked me, I wouldn't be able to use that kitchen knife to defend myself because it's in the kitchen. But I am still legally in possession of it. And I'm not immediately, preparing food right this second. And I'm not immediately eating food right this second. So I don't like the way this term is phrased because, I think that this guy should be able to have, just kitchen knives in his knife block. He shouldn't have to, buy a new knife every day, which technically, if you want to read this really strictly, is what's required. But, yeah, I would tweak this. I don't like the language, but whatever. I don't think they're going to breach him for just owning kitchen knives, but they would certainly breach him, for instance, if he was found down the street with, a machete or something. You are not to apply for any passports without prior order of a judge of the Court of King's Bench of Alberta. And if you have not already, you shall deposit all your passports, either currently active or expired, with the clerk of the Court of King's Bench by the end of the business day. December 5th. Okay, so they gave him a few days to do that. Cool. Terms of the probation order will be the same as the conditional sentence order without the curfew provisions. During the probationary period, there shall be no curfew provisions. So he's off house arrest, but the rest of the rules he's still got to follow. They bar him from having a firearm for 10 years, and he's also got to provide DNA. I'm not sure that there's much needed for, much reason for the DNA other than just the law specifies it. So yeah, this is an interesting case. I think it's a very fascinating self-defense case because, quite frankly, I don't really see what other options this guy had. And, yeah, it makes no sense there. So I think that this should have been an acquittal. I'm kind of disheartened that it wasn't an acquittal. And, every time somebody says, how can I be sure that, I'm using, that I'm defending myself properly? It's like, you can't. There is no magic word to, to that. So, yeah. Anyway, that's kind of that. So, it's a weird case. I just, I don't hate the sentence, but I do hate the conviction. Anyway, let me know your thoughts on this one. It's, as I said, it's a strange one there. And, yeah. Anyway, thank you for watching. I hope you found this to be interesting or educational. I also want to thank my Patreon supporters. There's a link to that in the description below. At the $50 level, Bottle Shock and Oz, Canada's National Firearms Association, PJs Forever, Canadian Coalition for Firearms Rights, Canadian Shooting Sports Association, Kyle Fox, Angela Skelton, Purple Dragonair, Cielo, Shavy, and Johan/Phoenix. And at the $20 level, Drunk All of the Baileys, Mark, Andrew Elsich, Larry Kalniak, Cameron Johnson, and Marvin CZ. Thank you for watching. Hope this has armed you with knowledge. See you next time.